The Supreme Court obviously handed down a number of decisions this week. Let's kind of take a step back. It feels like the season finale in so many ways, but let's think about all of the decisions that have come down in 2026. I'm curious if you were to draw a through line or think about a theme for these decisions over the last many months. I'm curious, Pema, how you would describe the series of decisions that have come down from the Supreme Court recently.
To me, the biggest theme of this term is the court's utter disregard for the decisions of Congress and for the laws, and substituting their own, frankly, policy preferences for Congress's decisions. I think the absolute, bomb case that came down yesterday, Trump versus Slaughter, that basically ended independent agencies and gave Trump the power to do what he wants with dozens of agencies that are supposed to be, insulated from presidential politics. Not only does it give Trump vast new powers, it tells Congress, you don't get to decide, we get to decide. And it substitutes its own decisions for Congress. And I think, as Isabela can talk about this for sure, they did the exact same thing in the immigration space. Congress has laws. You have to process people asking for asylum. If you want to end temporary protected status, you have to go through a process, right? Here's the process. If someone is a green card holder, these are the protections they have. In each of these cases, the Supreme Court said, essentially, the law is a suggestion. You don't have to follow it. So to me, what is really came screaming through this term is the Supreme Court taking power for itself, taking decisions for itself, giving a bunch of that power to Trump, and telling Congress to take a hike.
I would basically echo what Pema was saying. I think that is really the through line here. This unprecedented expansion of presidential power on so many fronts. And of course, we saw that in several of the immigration decisions. And I think, not only kind of taking that, oversight and kind of the power from Congress to, moderate the president, but also from the lower courts, right, from the judiciary. So in the decision that came last week, where it basically, the court paved the way for the Trump administration to kind of, have leeway to end temporary protected status for potentially more than 1 million immigrants living in the U.S. The Supreme Court basically agreed with the government's argument that the executive branch, decisions, determinations about how and whether to designate a country for humanitarian protection, that should be, exempted from any judicial review. And so, yeah, I think we see this again and again, coming up in this term, and maybe even it's been a pattern, it seems, for perhaps a little bit longer than that. But this really the Supreme Court just giving the Trump administration an exceedingly amount of power.
The term that I heard, I won't say I heard it more than ever before, but I heard it so often, was shadow docket. And maybe people don't know what that means. Pema, could you describe what the shadow docket is and how it was utilized through this term?
The shadow docket or emergency docket is cases that come to the Supreme Court in an emergency posture, and they are not fully briefed. They haven't had oral arguments. They aren't being considered necessarily on the merits, right? So, for example, Trump institutes a policy, a district court, a federal district judge puts it on hold, says, while we deal with this case, I think that I'm going to have to just pause this. And then Trump runs up to an appeals court and the Supreme Court and says, you have to let me institute this policy while the litigation is going on. And so those are the kinds of cases that, since Trump took office, have just flooded up to the court. I'm talking about more than 24 cases of the Trump administration running to the Supreme Court and saying, you have to let us do X, Y, Z, right? Don't let these district court judges block us. And this shadow docket has ballooned into a tool whereby the Supreme Court has, in almost every case, allowed Trump to proceed with policies that lower courts found were unconstitutional or illegal or both. And so, we're talking about, right, racial profiling in ICE stops, right? We're talking about basically letting the Trump administration not spend money that Congress told them to spend. We're talking about DOJ's ability to get, to get data that should be protected by the Privacy Act. We're talking about restrictions on transgender troops. We're talking about just all sorts of things.
I want to kind of turn our attention, huge win for the Constitution today with this birthright citizenship decision. I'm going to recommend our viewers and listeners do something radical, which is go read the Constitution, particularly the 14th Amendment, Section 1, as we're discussing it, because it's pretty clear. It feels like really pretty easy to understand that a person, I have it here, born or naturalized in the United States, is a citizen.
They really left this, big case to the last minute. The court struck down the Trump executive order that was intended to restrict birthright citizenship for the children born in the U.S. to undocumented immigrants and temporary visitors. So, that is the big headline here. This is a big victory for families, immigrant families, and I think for the Constitution. Only 5 of the justices actually ruled that the executive order is unconstitutional and violates the 14th Amendment.
Pema, what does it say about this court that this decision was ultimately so close, 5-4?
When I was waiting for this opinion to come down, I thought it would be 7-2 or maybe even 8-1. A 5-4 decision on the constitutional question is shocking. I feel shook. We are one vote away from completely upending our democracy. I think one of the things I've hammered in writing about this is that you cannot have a quote unquote American dream without birthright citizenship. The idea that anyone here has a shot to earn a living, live a happy life, that they get the benefits that everyone else gets, that they are treated equally, that is all premised on birthright citizenship. Without it, you revert back to a caste system like we had before the Civil War. And let's be clear, it's going to be mostly people of color who are relegated to this second-class tier. The implications of this are just astronomical, and we are one vote away from that. That is my reading. Some people will quibble that not everyone is fully there on certain parts of it, and I'm happy to get into the details, but I think the broad takeaway here is that 4 justices were willing to go, if not as far as Trump, pretty close. And I just think that it has to be a wake-up call to people about how extreme this court is. The other thing I want to say is that something that Isabela and I have both written about and looked into extensively is that this is just an incredibly easy case. You read the language of the 14th Amendment. It is crystal clear. The history is crystal clear. The common law, I know that sounds scary and confusing, but it is actually really clear. The Supreme Court has literally already upheld this. This is in every way an easy case. And the fact that these bogus arguments that just made no sense, even to non-lawyers, were gobbled up and regurgitated by 4 of the justices, really speaks to the way in which so much of this court is divorced from reality. Just truly unable to accept the history for what it is, unable to read the text and accept it for what it is.
This perhaps should have been, some will say, an unanimous decision, right? There are centuries and of legal precedent and history and principle and tradition that back this universal interpretation of the 14th Amendment and birthright citizenship. And instead, we saw that, quite a number of justices were willing to put that into question and potentially, put into contention the citizenship of millions of people and the rights that come with that.
Tuesday is a big victory for the Constitution and equality, but it is also a warning. We are headed in a bad direction.
I don't think it's an exaggeration to say this was one of the most important cases in the history of the Supreme Court. And Samuel Little, like he says that himself in his dissent. The court's opinion, the majority opinion, kind of shows, how they painstakingly went through looking at all like the history of this legislative history, like the endless like texts about the British common law and looking back again at their 19th century precedent, and again reaffirmed the 14th Amendment and the Citizenship Clause and this inclusive view of birthright citizenship. Essentially, Justice Jackson kind of chronicles the way that freed Black people fought, right? They claimed their citizenship based on birth on American soil. And that history is, really important to understand why this inclusive view of birthright citizenship is so crucial to, the understanding of what America is and then the foundational principles of this country. And to think that there are some justices who would be, potentially would welcome, arguments that could take us back to the Dred Scott era, and as Pema said, sort of like reinstate a caste regime where, people born on U.S. soil have different rights. It's, I think, really troubling.
The biggest part of this decision document is Justice Thomas's massive dissent, which basically is an alternate history of birthright citizenship and the Civil War and Reconstruction. In a concurrence, Justice Jackson takes on Justice Thomas. Basically, I think says, like, here's how you can do history right. Here are some sources you can actually look to, and let's give space to the freed Black people and their expansive conception of liberty and why they were agitating not just for themselves to become citizens, not just to narrowly overturn Dred Scott, but to expansively overturn Dred Scott so that you would never again allow politicians to demote a disfavored group to second-class status. And she has this line that is so good. And she says, "The teacher who scolds a student for bullying a classmate hopes the student learns the broader lesson of treating everyone with kindness, not just that one kid." So the way in which Thomas tries to narrow and cabin birthright citizenship, just like Trump, is to say that the Birthright Citizenship Clause only applied to the freed people, and it should not apply to these other groups, people today who would also benefit from that. And she's saying, no, just like the schoolyard bully shouldn't pick on one kid, shouldn't pick on any kid.
Yeah, I found here the part where she really goes to town with it, and she says, "Freed Blacks fought for the shared humanity of all people, and including immigrants." I thought that was like one of the most powerful parts of this whole decision. And she also says, "The Reconstruction Amendments were an anti-caste, anti-subordination reset for the nation, not a mere spot treatment for the dark stain of slavery."
And this is not the first time she is criticizing Thomas for how he does history and how he excludes Black people and the Black conventions, excludes Black voices from his historical analyses. But there is also like a meta point I think she is making, which is that the Black people during Reconstruction did not want this to happen to anyone else. They didn't want to just pull the ladder up behind them and let everyone else fend for themselves. But that is exactly what Thomas does.
Right. And I think that the majority, they write about it a little bit in the sense that they say that, the dissenting opinions would essentially pitch Black people against immigrants when, that would have never been the intent.
There's something here that has always irked me, is the selectiveness with which Clarence Thomas particularly chooses to be colorblind and when he chooses not to be colorblind. Like, at the heart of Thomas's dissent is a real race consciousness in his mind within the Constitution. But if we were to just go back a couple of years to the SSA decision, to the affirmative action decision, like at the heart of his entire point is that the Constitution is colorblind and that it is not race conscious. And so there's this contradiction that I don't think we spend enough time really pointing out. I think there's an incoherence present in Justice Thomas's perspective on the different ways to read the Constitution. And it really is mostly what I think he already holds as a belief. And then he kind of morphs and shape shifts the Constitution and history to fit that preconceived conclusion. And I think that is certainly illustrated right here. Obviously, the Trump administration took a couple L's this term. What do we anticipate this administration will do, Isabela, around TPS? Obviously went in their favor, but birthright citizenship, which again is connected because the children of those who have temporary protected status are those that were more or less being targeted. One of the groups being targeted by the birthright citizenship executive order. My question is, what will the administration do next? What do we anticipate coming down from the Trump administration over the next days, weeks, months?
Yeah, I mean, again, I really feel like I need to again emphasize how big of a deal this decision was. The decision stopping the Trump administration from restricting birthright citizenship is a big deal, right? And a crisis has been averted, and I feel very confident in saying that. But I also think that that decision, as important as it is, has to be understood in light of so many other decisions, some of which we talked about here, that have come out this term and that are incredibly harmful and problematic. And you know, in the case of the immigration decisions, again, the one that really is a fatal blow to TPS. And another decision that, you know, basically allowed the administration to restrict access to asylum even further at the border. These are all part, right, of a larger anti-immigrant agenda that the Trump administration, you know, has pursuing very aggressively since the beginning. This unconstitutional effort to redefine what citizenship is part of that, right? Is an attempt to create a country that looks less like a nation of immigrants. I mean, I think it's as plain as that. And being that the Trump administration took a hit here, right? This is a big loss for their agenda, even though, you know, the TPS was a huge one. That means that they are going to potentially have hundreds of thousands more people who they have delegalized, they have de-documented, who they can now arrest and deport potentially, right? But this executive order, their defeat in this case, I think might make the administration want to retaliate in some way, you know, even further, maybe somehow go after an even more aggressive sort of like, you know, immigration crackdown regime. I think it's safe to say that the, you know, for the now formerly TPS holders, it's I mean, it couldn't be a scarier time, and I think the Trump administration is going to continue to find all the ways they can possibly conceive, you know, whether they are outside of the law or they are trying to use the law in their favor somehow, to continue to target immigrants regardless of their status in the country.
You know, the conversation about court reform has been growing. We've been having it. And I'm curious for Americans who are, you know, frustrated and maybe even tired of the way in which this court has effectively stepped into almost a legislative kind of position, it feels, in so many ways. They've almost taken the place of Congress in so many ways. I'm curious what people can push for or advocate for around court reform. What would change the way the Supreme Court interacts with the American people and our lives? I mean, we have decisions around transgender students, in children, in sports, all the way up to voting rights and birthright citizenship. Like, how do we kind of rein the Supreme Court in?
I mean, I think, like, first of all, The Supreme Court is a co-equal branch of government, and yet virtually everything it does is subject to congressional legislation. So, with limits, but Congress can add justices to the court, right, to change the ideological and political balance, just to essentially reject one court and create another. That is Congress's power under the Constitution. Congress can also do what's called jurisdiction stripping and say, like, in the language of a law, like, the courts can't review this. People also talk about term limits. That's sort of like debatable whether or not that is a constitutional reform. And then there's the question of, does political pressure itself, does the sort of threat of these reforms change how the court acts? I think that is the lesson we take from the 1930s when FDR threatened court packing, and even though he didn't get it through, and it was rejected, I think that is one of the reasons that the court changed its tune in the late 1930s and stopped striking down his New Deal legislation. So there's evidence that those threats are also something that the court takes into consideration. But look, I think when I talk to advocates about court reform, I do think they believe that Louisiana versus Calais, the huge decision effectively striking down the Voting Rights Act that the court released 2 months ago, reawakened people's anger at the court and the calls for reform. I'm really interested to see if birthright citizenship does that as well. I think there's like a real complacency politically about the court, but maybe, one vote away from, changing the 14th Amendment is a wake-up call. We'll see. The last thing I'll say about this is that I don't think there's any way it's not going to be a big topic during the 2028 campaign cycle, which essentially means starting in January, right? I think that advocacy groups will be putting pressure on candidates to talk about this, and, we'll see whether or not candidates decide that this is a way to, push their advantage. But I do think that just the fact of a campaign will sort of push this into the bloodstream a little bit more.
Isabela.
This might not be totally to this point. I just wanted to kind of go back to one thing. If the Trump administration had gotten it their way with the birthright citizenship case, it would have been devastating. And, we could talk about all the ways in which it would be problematic, and not, the least of which would be just unleashing chaos across the country and essentially making it so that a birth certificate is no longer enough, not enough proof of citizenship, which would have implications not only for immigrants and the children of immigrants, but also for like Americans, broadly speaking. And I think, again, like, what this case was so important because, again, it really does speak to what I think is a threat to, what we understand to be constitutionally guaranteed rights, right? This was about automatic citizenship, right? Citizenship upon birth on soil. But what happens, what about the other amendments and like the other, constitutional rights that could, I guess, also be up for debate, just, if we judge by where some of these justices, seem to be at. And so I think it's kind of also important to look at this from this broader perspective, right? It's like today was birthright citizenship, but, what rights could be called into question next? And I think that should be really scary for everyone, right? For all Americans.
You two have both done incredible work through this term. And so a huge thank you to you. I'd love to give you an opportunity to uplift one piece that you'd like to highlight and encourage folks to go read.
Isabela and I wrote a piece together I would highlight. I believe we called it The Nonsense Case Against Birthright Citizenship. We dug into essentially the arguments against birthright citizenship, the arguments that lost the day on Tuesday. But they came closer than they should. And I think part of what is scary about that is how bad those arguments were. And that was sort of the lesson of that story. So
if anyone is curious to sort of like understand a little bit more of what were some of these arguments from the government and the conservative, movement that was backing it up, and why it was debunked as revisionist history in this court's opinion, I think that piece might be really helpful.
Isabela, Pema, thank you so much for your time.